Welcome to The Explainer. Today, we're diving into a part of government that pretty much runs your daily life, but you probably don't even think about it. Administrative law.
Look, we all get the basics from school, right? Congress makes the laws, the president carries them out, and the courts sort out what they mean. Seems pretty straightforward. But that neat little picture leaves a huge gap. I mean, who actually gives you your driver's license? Who decides if a new medicine is safe to use? That's where the real machinery of government kicks into high gear. The answer? It's in this massive, powerful, and kind of hidden world that some people even call the fourth branch of government. So let's pull back the curtain on these administrative agencies, the real engine room of the modern state. So here's how we're going to break this all down. First, we'll figure out what these agencies actually are. Then, we're going to look at their two unbelievable powers, making rules just like a legislature and deciding cases just like a court. And finally, we'll tackle the big one, what stops them from having way too much power. All right, let's jump right into Section 1, the government's engine room. So for real, what is an administrative agency? Well, at its core, an administrative agency is basically any government body that isn't a court and isn't a legislature. Congress will pass a big, broad law, let's say about keeping the air clean, and then an agency gets created to handle all the specific details to make that happen. You deal with them all the time. The LTO for your license, the SSS for your benefits, COMELEC for elections. They are literally the government's boots on the ground. And that really gets to the whole reason they exist in the first place. I mean, think about it. Our lawmakers can't be experts on everything from nuclear energy to food safety. It's just not possible. So they pass a general law and then delegate the authority to an agency that's packed with specialists to hammer out all the technical, nitty-gritty details. Okay, now this is where things get really, really interesting. Agencies don't just follow the law. In a lot of ways, they actually get to make the law. Let's look at their first huge power, acting like a legislature by making rules. This is called quasi-legislative power. And quasi is just a fancy word that means sort of or almost. So they're not Congress, but they get to create rules. You'll see them called implementing rules and regulations, or IRRs, that have the exact same force as a law that you or I have to follow. Now, agencies put out two main types of rules. First, you've got legislative rules. These are the heavy hitters. They're basically brand new rules that carry the full weight of the law. Then you have interpretive rules. Think of these more like the agency's official guide, explaining how they understand a law that's already on the books. They're there to clarify things, but they aren't binding law on their own. But an agency can't just go on a power trick and make up whatever rules it wants. No way. There are some very strict legal guardrails. First, the rule has to be authorized by an actual law. Second, it has to stay within the boundaries of that law. Third, it has to follow proper procedure. And finally, and this is a big one, it has to be published. No secret laws allowed. If a rule fails even one of these checks, it's invalid. Simple as that. So they can act like a legislature. That's already a lot. But that's only half the story. Believe it or not, they can also act like a court and decide actual cases. Yep, this is their quasi-judicial power. So if a dispute pops up in their area of expertise, say an employee claims they were illegally fired, the case doesn't just go straight to a regular court. It first goes to a special body, like the National Labor Relations Commission, which acts like a court, listens to the evidence, and makes a binding decision. But here's the catch. These agency courts don't work exactly like the ones you see on TV. Their main goal isn't just to administer justice in some broad sense. It's to specifically carry out the policy of the law they're in charge of. And that means their procedures can be a lot more flexible and less formal than a traditional court, which is locked in the super strict, rigid rules. But even with all that flexibility, fairness is totally non-negotiable. The courts have laid down what they call the cardinal requirements for due process. This means you always have the right to a hearing. The agency has to actually consider the evidence you present. The decision can't just be pulled out of thin air. It has to be supported by substantial evidence. And crucially, they have to write it all down so everyone knows exactly why they decided the way they did. Okay, let's take a breath. Agencies can write rules like a legislature and decide cases like a court. That is a ton of power. Which brings us to our final and maybe the most important section. What on earth keeps all of that power in check? I mean, it's the essential question, isn't it? If you think an agency made a terrible rule or decided your case completely unfairly, what can you do?
What's to stop them from just going rogue and doing whatever they want?
And the answer, thankfully, is judicial review. At the end of the day, the regular court system is the final referee. Judges can step in and review what these agencies are doing to make sure these powerful engines of government stay on the rails. But hold on, it's not a free-for-all. You can't just sprint over to the courthouse the second you get a decision you don't like. The whole system is built to respect what these agencies do, so the courts have set up a few key rules you have to follow first. First up is something called the doctrine of primary jurisdiction. This is all about respecting the experts. If a case involves super complex technical stuff, like setting electricity rates or something, a judge will basically hit the pause button and say, whoa, this is their sandbox. Let the specialists at the agency take the first shot at this. Second is the doctrine of exhaustion. The easiest way to think about this is you have to play the game all the way to the end. Before you can ask a court for help, you have to use every single option you have inside the agency itself. You have to file that internal appeal. You have to file that motion for reconsideration. You have to give the agency every chance to fix its own mistake before you bring in a judge.
And as the Supreme Court itself put it, the agency should be allowed to perform its function to the full extent that the law grants. That's the logic in a nutshell. These rules make sure the system works the way it's supposed to, and that courts only get involved when it's absolutely necessary.
So where does that leave us? This fourth branch of government is the essential engine that makes our complex world run. But all that power creates this constant, delicate dance. How do we get all the benefits of their expertise without giving up the accountability and the checks and balances that are so crucial to our democracy? Well, that is the central, ongoing question right at the heart of administrative law.